In this video, I will briefly be discussing what a motion to quash is and when it is most appropriate to file one. My name is Brian Fishman. I'm a Philadelphia criminal defense attorney who represents individuals charged with various crimes in Philadelphia, Montgomery, Delaware, Bucks, and Chester counties. What is a motion to quash? Well, if you are charged with a felony in Philadelphia, you are entitled to a preliminary hearing. At that preliminary hearing, the judge is not deciding whether or not you are guilty or innocent of the crime. Instead, he or she is determining whether or not the Commonwealth can prove what's called a prima facie case. And all that means is that the Commonwealth needs to prove, one, a crime has been committed, and two, more likely than not, you were involved in that crime. If that has been proven, then the case gets sent on to the Court of Common Pleas for a trial on those charges. It's important to understand that the judge who is deciding the preliminary hearing is not ruling on your innocence or your guilt, and is also not ruling on the credibility or the believability of witnesses. However, there are times when the municipal court judge will send a case on to trial when certain charges have not been made out. Let's say a gun was found in a car and there were multiple people found in the vehicle and you were a passenger. You get charged with gun charges and the case gets sent on from the preliminary hearing to the trial level because the municipal court judge believed there was enough evidence. There is case law that would suggest that perhaps the judge was wrong and there was not enough evidence even under those circumstances and that low burden of a prima facie case to send the case on to trial. In that situation, a defense attorney would file a pre-trial motion to quash that would get argued at your pre-trial conference. And if the higher court, the judge in the Court of Common Pleas agreed, they could quash or dismiss those bills of information dealing with that evidence. In a case that I gave as an example, if you were charged with gun charges only, that would dismiss the entire case. However, it's important also to understand, in cases where a victim testifies and testifies falsely at a preliminary hearing, that is not a case that is generally ripe for a motion to quash, because that comes down to the credibility or whether or not that witness should be believed. You will have your chance to cross-examine that witness further at a trial and to really go after them and test whether or not they're lying about what happened. And a judge or a jury will decide the facts and whether or not you've been proven guilty beyond a reasonable doubt. So generally, in cases that involve credibility, a motion to quash is not relevant. Instead, a motion to quash is most appropriate in those types of cases with possession with intent to deliver, possession of a firearm, cases where there is a question of law as to whether or not certain charges have been made out. If you'd like to learn more about motion to quash, myself, or any of the criminal offenses that I defend against, I welcome you to visit the below website, and I look forward to seeing you soon.